A litigation prep investigation can help an attorney or party to a case get a tactical advantage prior to beginning the court procedure. For example, if you have information on the prior cases that the parties were involved with, the counterparty, the attorney, maybe even the expert witnesses, you can get an idea of how those parties have operated in the past, what succeeded for them, and what hasn't. And knowing that will give you opportunities to be able to parry some of those strategies in advance. The other thing that you could find out about is the associations they have with various witnesses, not necessarily expert witnesses, but witnesses in a case that might be providing information or testimony to benefit the counterparty. If you are involved in litigation with a corporation, having information about employees or even former employees of that company might be valuable to understand the nature of the corporate culture or how those other people have left the company and where they are now. Of course, litigation prep many times includes asset investigations to understand what the snapshot of the assets are. One of the reasons why attorneys will do that is to get an idea of if it's valuable to go ahead with that case. But even if it is, establishing a snapshot of the form and amount of those assets prior to the case will be valuable if later on there needs to be asset recovery to get an idea of what changed during the case and when that changed. If the case turned bad for the counterparty and all of a sudden assets were moved, that could be valuable in asset recovery to show bad faith. The last thing that's very valuable in litigation prep is to be aware of private investigator activity for the other side. In many cases, private investigators will use techniques that technically are not legal. They may put GPS devices on cars. They can do searches for data that's not available. They can do things like social engineering to get copies of bank statements or even things like cell phone accounts. If you're aware of those, you can present those in your case to show, again, bad faith and maybe even exclude some of the evidence that's presented by the other party.